Good evening, everyone. Am I audible and visible? Yes, guys. Varun Raj Tiwari, good evening, good afternoon. Niva Kavya. So we are starting one short series from today, around 45 to 1 hour session. We are going to discuss some important topics in forensic medicine and also related MCQs. So let's start. Yes, fine. Rakesh, fine. So courtroom procedure. Before that, we have two plans, FMGE one plan that is at 3499 and PW Meded one plan at 4999. So let's start. Courtroom procedure. As you know, doctor is a expert witness, and like example, postmortem certificate, wound certificate, age certificate, all these are medico-legal documents. So these documents should be cross-examined in court of law. Then only it is legally valid. Courtroom procedure. As you know, there are 5 steps. The step number 1, that is oath. The second one, examination in chief, cross-examination, re-examination, the arguments, and the final judgment. Before discussing actual topic, can you identify these personalities in relation with court of law? Can you try? The important personalities are important person inside the court. The one is doctor. So as you know, doctor is a witness, right? He is inside the witness box. Then we have other characters or persons. Can you identify? Yeah. Judge. Judge or magistrate, your honor, sir, my lord. So judge is the supreme, as you know. So there are different types of court. Supreme Court, High Court, Session Court, First Class Magistrate Court, Second Class Magistrate Court. The power of First Class Magistrate, 3 years and fine. Second Class Magistrate, 1 year and fine. Chief Judicial Magistrate, 7 years and fine. Session Court, it can pass any sentence including death sentence. Additional Session Court can pass any sentence including death sentence. High Court can pass death sentence, and the Supreme Court, which is supreme, located in New Delhi. Right? Okay. Middle one, judge. And the second character here you can see, public prosecutor. So we call it as PP. So in simple word, PP, public prosecutor, APP. The government lawyer, the government advocate is classically known as public prosecutor. In criminal case, as you know, in criminal case, the accused versus state, the counsel of the victim, that is public prosecutor. And consider him as defense advocate. Defense are the opposite party. Okay? Witness, that the doctor is the witness. Judge, public prosecutor, and defense lawyer or defense counsel. Okay? So all of you just type PP in the chat box. PP. So that you can interact with me. You can keep me awake. You can keep yourself awake. Just write PP. So 3 marks question in your university exam, the power of different court. Okay. Then courtroom procedure very commonly asked 5 marks question. Commonly asked in INICET and NEET PG exam. Many questions including FMGE. So that's great. Good. Kamran Bhatt, Nashita, editing, assets. Good. Rocket. Thank you all. Let's start the procedure one by one. The order of examination of witness. The witness can be common witness or it can be expert witness. Doctor can be both common witness and expert witness. Expert witness, like example, fingerprint specialist, FSL specialist. Okay. In general, doctor is expert witness. The order of examination comes under 143 BSA. BSA means Bharatiya Saksha Adhiniyama. Previously, it was Indian Evidence Act. 143 BSA. MCQ can be asked. Order of examination is given by dash BSA. 143 BSA. Try to memorize this. Yes. It starts with the oath. As you know, oath. शपथ बोलते हैं हम हिंदी में. शपथ, oath. It is given under section 223 BNS. MCQ. What is oath? The oath is declaration required by the law which is compulsory for a witness before he gives evidence. It's mandatory as per the law. Common witness, expert witness, and any person, politician, any person, it is mandatory. Okay. So normally the oath is like this, as you know. I do swear in the name of God, so may affirm that what shall I state shall be the truth, the whole truth, nothing but the truth. This is oath. In Hindi, मैं ईश्वर के नाम पर कसम खाता हूं, ईमानदारी से पुष्टि करता हूं कि जो मैं कहूंगा वो सत्य, संपूर्ण सत्य और सत्य के अलावा कुछ भी नहीं कहूंगा. This is the standard oath statement. Okay, fine. So let's come back to the topic. Now, can anyone answer? The oath is not required in children. What is the age under which the oath is not required? Can anyone answer? Options are 12, 18, 16, 21. Oath is not required in child of age less than dash years. Can you try, guys? Rocket, Anand, Dikshit. Oath is not required in age group less than 12 years. MCQ. Good. Many answered 18. No, it is 12. Try to understand the consenting age for medical examination 12 years. Medical legal examination also 12 years in examination of victim of rape. For surgery it is 18 years. For consent for sexual intercourse 18 years. Driving license 18 years. Organ transplantation 18 years. But in oath it is 12 years. The child of age less than 12 years, the oath is not required. ठीक है, good. चल, now there is one more very important फंडा, बार बार पूछते एग्जाम में, परजुरी, 3 मार्क्स क्वेश्चन, परजुरी. The perjury means giving false evidence under oath, or the witness one who is not revealing truth, not telling truth under the oath, is known as perjury. So perjury is a broad term. It includes hostile witness, it includes medical legal documents also. It's a very broad term. The perjury defined under, very commonly asked, defined under definition 227 BNS. What is perjury? 227 BNS. Punishment 229 BNS. Previously 191 and 193 IPC, now it is 227 and 229 BNS. So all of you write in the chat box 227 and 229 in the chat box. लिखो, it's compulsory, like oath is compulsory. You need to write 227 and 229 in the chat box. Yes, come on guys. Okay. Again, question asked, what is the difference between perjury and hostile witness? The perjury is a broad term. It can be person, it can be document. But hostile witness is a person, one who gives different statements. One statement in police investigation, and during in court, he tells different story. One who changes his statement is known as hostile witness. ठीक है? Yes, good. शशांक भारद्वाज, great. चलो आगे देखते हैं. The next step is examination in chief. That comes under again section 142 BSc. It is conducted by public prosecutor. So याद रखना पड़ेगा, public prosecutor. So public prosecutor going to explain the facts of the case to the court, like what happened, like example rape and murder, what happened that day, how many people were there, what was the weapon used, what are the evidences we got, what are the trace evidences we got, and also about the witness. So he is going to explain the court about the case, public prosecutor, the government lawyer, and try to understand. Leading questions are not allowed. Leading questions are allowed in cross-examination. The leading question means yes or no type of question, or any question which has answer in it is known as leading question. Let's have a discussion about it. Like example here. Now look at this. हत्या में किस हथियार का इस्तेमाल किया गया? Is it a leading question or non-leading question? Can you just tell me? हत्या में किस हथियार का इस्तेमाल किया गया? What was the weapon that is used in the case of murder? Is it leading question or non-leading question, or it is normal question? बताओ जल्दी. Come on guys, try. Let's interact. I said leading question means the question which has answer in it? Yes or no type of question? No, बेटा ये नॉन लीडिंग क्वेश्चन है. लीडिंग नहीं है, नॉन लीडिंग है. दूसरा देखते हैं. क्या चाकू की लंबाई 10 सेंटीमीटर थी? Now look at this question. This question is framed in such a way that either witness should answer yes or no. This is leading question. Leading. Then one more. चाकू की लंबाई कितनी थी? Is it leading question, non-leading question? Now answer. चाकू मतलब weapon. What was the length of the weapon used? So there is no answer in it. It can be 5 centimeter, 10 centimeter. Normally weapon is 15 centimeter, 15 inches, 15 centimeter. Depends on the weapon. Is it leading, non-leading? Again, it is non-leading. So try to understand. A non-leading question है. One more question. पोस्टमार्टम किसने किया? पोस्टमार्टम FMT गुरु ने किया. नॉन लीडिंग क्वेश्चन है. So this is the concept. Leading questions are allowed only in the cross examination, not in the examination in chief. Leading question means yes or no type of question which has answer in it. So let's come back to the topic. So Rakesh and others, is it clear? And now here one more funda. Leading question can be asked in examination chief when witness is hostile. याद रखना पड़ेगा आपको. When witness is hostile, when witness झूठे है, then you can ask leading question. Again, question asked. In hostile witness, leading questions are permitted even in examination in chief. MCQ. Okay, fine. So this is about the examination chief. Basically facts of the case. Okay. Then comes his cross-examination. The cross-examination by advocate, defense advocate. What is the motive of cross-examination? What is the objective? To test the accuracy of witness. Sometimes what happens? There are many weak points. There are some wrong statements in the witness, in the statement. The cross-examination going to explain the court, the witness is not correct, the witness is not accurate, or it is false witness. That is the role of cross-examination. The cross-examination is one of the very important component of courtroom proceeding. For any judgment, there should be proper cross-examination by defense advocate, MCQ or opposite party. Comes under 142 BSc. MCQ याद रखना पड़ेगा. Leading questions are allowed. LQ allowed. Now my question is, what is the time limit for cross-examination? Time limit. Time limit क्या है? 1 दिन, 2 दिन, 10 दिन, 1 महीना, 2 महीना? What is the time limit for cross-examination? Try. Shashank, Rocket. Cross-examination, no time limit. In many cases, you know, as an expert, I can say, there is no time limit. It can be 1 hour, sometime it can be 2 hours, sometime entire day, sometime it can be 2 days, 3 days, 4 days. In one murder case, They called me for 4 days for the cross examination. In case of murder, I was the forensic expert, that is postmortem certificate. Me cross-examined for about 4 days. In one hi-fi case, I don't want to reveal that. Okay? Yes. Chalo? Fine, is it understood? Have you got all the points, guys? So then comes is re-examination. आपको याद रखना पड़ेगा. Next step क्या है? Re-examination है. Re-examination to clear any doubts. See, there are hundreds of doubts during cross-examination. So all these doubts are cleared by public prosecutor again. Again, public prosecutor, he is going to explain the court that, and he is going to solve the doubts. Try to understand, no new questions, okay? There is no new topic in this. So in re-examination, only the old topics discussed in cross-examination, examination chief. No new topics in re-examination. So, but with court permission, they can ask new questions as well. Yes, fine. Re-examination हो गया. So re-examination fine. Then क्या होगा? Then there will be arguments. Arguments between party A and party B. Same party, opposite party. Public prosecutor and defense. Then there will be judgment. Judgment. So judgment can be innocent or guilty. Like example, 64 BNS, punishment for rape. Dowry death, 80 BNS. So depends on the witness, depends upon the statement. Okay. So this is how the order of examination of witness takes place in court. So if you have any doubt, you can ask me. Yes, Shashank, any doubt? I'll repeat again. The courtroom procedure, there are 5 important steps. Starts with the oath. Oath is not necessary in age less than 12 years. Oath comes under 223 BNS. Oath is mandatory and compulsory. Taking oath, telling lie, perjury बोलते हैं इसको. Perjury broad term है. इसमें hostile witness भी involve होता है. Hostile witness is a person. 227 definition of perjury है. 229 is punishment for perjury. So giving false fabricated evidence or creating that is basically 228 BNS. याद रखना. So leading questions are not allowed in examination chief, but they are allowed when there is a hostile witness. 142 BSc. Basically by public prosecutor. Cross examination by defense lawyer to test the accuracy, the weak points, to help the accused, or to to give a light on the case. Sometimes some FIR may be biased, so it all cross examination, so it will be sorted out. Then re-examination 142 है, and final arguments and judgment. हाँ, yeah, every step is compulsory है. Every step is compulsory. This is how the routine takes place in court. 5 steps. Good questions from students. That's great. Try to memorize MCQ 142 BSA examination of witness. याद रखना, witness can be common witness, expert witness. So doctor can be both common witness and expert witness. 143 क्या है? Order of examination है. 146 क्या है? Leading question. Leading question मतलब any question suggesting answer. याद रखना पड़ेगा. BNS, BNSS and BSc. So 3 important codes. BNS means भारतीय न्याय संहिता. It is a code of punishment, a code for punishment. Like example, 64 BNS, rape. 116 BNS, grievous hurt. 106 BNS, negligence and death. 70 BNS, gang rape. So 116 is commonly asked in the exam. BNSS, Bharatiya Nagarika Suraksha Samhita. In that you must know 184 BNSS. Examination of victim of rape. R52 BNSS. Examination of accused of rape. 52 याद रखना पड़ेगा. 194 BNSS. Police inquest. 196 magistrate inquest. We'll have a different session about all these IBCs and BNSS. BSA, one BSA very commonly asked is 26 BSA. That is dying declaration. ठीक है? Yes, good. So this is about the some important MCQs. चलो आगे देखते हैं. So now we have certain questions about the same topics. So there are 10 MCQs are there. You try to go through all the MCQ and try to answer. I'll give you around 10-15 seconds time. The first question, yes, before that, are you ready? So ready for the MCQ, guys? Ready? Say yes or no. INICET, one of the toughest exam, and NEET PG exam. Previous year PYQs. PYQs matlab previous year questions. Say yes for the test. Yes, okay. Pahla question. True about oath. All except. There are 4 options. Compulsory for witness before he gives evidence. After taking oath, the person becomes legally bound to speak the truth. A child of age less than 18 years, oath is not required. Refusal to take oath is punishable with 6 months of imprisonment. 6 months. Under various sections of BNS, that is not required for your level. 6 months. क्या आंसर हो सकता है बताओ? A ट्रू है, कंपल्सरी है. B is also true, otherwise it can be perjury. C is also true. 18 लिखा है ना, ये wrong है. It should be less than 12 years. So the answer is C. So the first to answer, Anand. Anand, very good answer. Good. Second question. True about hostile witness and perjury. Option A, except लिखा है, ठीक है? इसमें है except. Hostile witness is a person, whereas perjury, the act committed by him. So go through all the options, try to answer. Hostile witness is a person, whereas perjury is an act committed by him. That is true statement. I said already. Hostile matlab person hai, human being hai. Perjury matlab it can be document also, person also. Done. Punishable under 229, वो भी ठीक है, सही है, ट्रू है, ठीक है ना? Leading questions are not allowed in examination chief of hostile witness. So this is false. Best victory case, that is a true statement. So again answer is C. So again the answer given by good notes. Good notes, answer is C. हो गया second. Third, reasons for a witness to turn hostile. Hostile. Option A है threat and fear. Yes, very common. Especially in high-fi cases, there can be threat. You can take the police protection in that case. True है. Personal gain like bribery, yes, money. The vitamin M matters a lot. Yes, common cause है. Sometimes love affair with the victim, love affair with the whatever that is. Jealousy, yeah, some motivation that can be cause for hostile. Delayed prolonged trial along with the prolonged exhaustive investigation. Yes, answer is all the above. So this can be a 3 marks question. So answer is D. Good. Which of the following is a leading question? When he saw the body, what was the weapon used in the murder? What was the length of the knife? Was the length of the knife is 10 centimeter? So the answer is D. Simple it is. Which statement is right? Right and wrong. Only one statement is right, or all the above. A child below 12 years of age is not required to take oath. That is true. Person with mental illness, intoxicated person, cannot testify in court of law. That is also true. Like person suffering from schizophrenia, suffering from delusions, hallucinations, the statement given by him is not valid. Definitely invalid hai. That is true. You know, McNaughton's rule says that any criminal act by insane person, it is not punishable. 22 BNS. Came very commonly asked question. McNaughton, he was the patient suffering from delusions and hallucination, third person hallucination. He was a normal citizen. He was having diagnosed case of delusions and hallucination. He was having constant delusion of the Prime Minister of England was trying to harm him or trying to kill him. So what he did, the McNaughton himself tried to kill the Prime Minister. During that process, he killed his personal secretary, Robert Neal. Then he was arrested. They came to know that he was suffering from mental illness. He committed the crime under the delusion. There is no guilty mind and guilty act. That is what given in McNaughton's rule, section 22 BNS. McNaughton was the person, the patient suffering from schizophrenia. Okay. Dumb witness can also testify in writing. That is also true. You must have seen in movies. Answer है D. D है. Very good. Many answered correctly. D. Now this is very, very important question. Try to answer about the summonses. You have received 2 summonses, like 2 criminal court summonses or civil court summonses, attended on the same date, same day. So tomorrow, Monday is court, and there are 2 summonses to me. Now, what is the best preference? Option A. The one you receive first will be given preference to, irrespective of type of court and the case. What do you think? Irrespective of court? No, beta, no, it is false. ऐसा नहीं है. The first thing, you should respect the court. If it is from the higher court, you need to attend the higher court. Like high court summon and session court summon, you need to attend high court, not the session court. That is the rule number 1, higher court. Rule number B, criminal cases will be given preference over civil cases irrespective of date of receiving summons and type of court. No, wrong hai. Again higher court, irrespective of type of court, that is false. False. ऐसा नहीं है. Like example, a civil suit, summon from the high court, session court criminal case, I need to go to high court and you need to inform the lower court as well. So it is the higher court that matters, like Supreme Court, High Court, Session Court. So there is a hierarchy is there. Okay? Higher court will be given preference over the lower court irrespective of date of receiving summons and type of case. Yes, that is always true. याद रखना पड़ेगा. C सही है. BNS under which case is filed will be used to decide the preference. No, that is false. So answer है C. C, I think Aishwarya Baligar, excellent answer. Aishwarya. Good. Then, leading questions are allowed in cross-examination, chief examination, the witness declared hostile if court permits. All the above. D. True about examination in chief. First examination of a witness in court of law. Yes, it's a first examination. True hai. Witness examined by a lawyer of that has called him. Yes, that is true. Like example, in case of murder, so usually called by the public prosecutor, that is state, accused versus state. We are the witness. So witness examined by the lawyer of that called him first. Yes, true. So again, there are prosecution witness and defense witness. So witness always examined by the lawyer of that is called him. Leading questions must not be asked there. Yes, that is also true. आंसर क्या है बताओ? डी आंसर है. डी है. गुड. BNS corresponds to fabricating false evidence. Fabricating false evidence मतलब create करना, false evidence create करना. Maybe some motive is there, maybe love affair, bribery, whatever that is. So fabricating false evidence, answer would be 228. P आंसर है. 227 क्या है बताओ? परजुरी डेफिनेशन है. 221 क्या है? 229 है क्या है? डेफिनेशन हो गया. पनिशमेंट है. 116 इज ग्रीवस हर्ट. आंसर है बी. बी है. So nobody has answered. So 227 is giving false evidence. Whenever word fabricating false evidence, 228 है. Punishable under, both are punishable under 229 है. Giving false certificate 234 है. 116 reverse hurt है. Reverse hurt has 8 clauses. Okay, 8 clause, 2 weeks now. That is 15 days, not the 21 days. And the last one. BNS corresponds to issuing or signing false certificate. Like example, one person will come and he will ask you to give some false wound certificate. Sir, एक wound certificate दे दो, I'll give you 5,000 rupees. Okay, so giving or signing false certificate is punishable under 234 है. Punishment है 7 years of imprisonment. याद रखना पड़ेगा. 7 years. So never sign or issue any false medico legal certificate. Don't do that. The punishment can be 7 years of imprisonment if it is proved. D आंसर है. So this is about the 10 questions and a short topic, one short series, the courtroom proceedings. If you have any doubt, you can ask me. Before that, you just tell me your score. Score at the end. चलो बताओ जल्दी. Score. Aishwarya, what is your score? Aishwarya, Anand. Good notes. Rakesh. So let me your score. So this is a first class of one short series. So we completed in detail about courtroom proceedings and MCQs, and very, very important topic. So what is your score? Okay, Rakesh got 4 out of 10. Others? What about others? So this completes your today's topic. So let's come up with some more important topics. The brief discussion of some important topics in forensic medicine in upcoming classes. So Anand got 9. So if you have any doubt, you can ask me for next 2 to 3 minutes.